So you're driving a truck for your employer and you're making a delivery. You got to get out of the truck, so often that you decide that you're going to leave your seatbelt off just all the time while you're making your deliveries and have it click behind you. So, you've heard these blowhards at the safety meetings that they have at your employer, always say, hey, look, you guys got to wear your seatbelts all the time. And of course, you've got some written safety rules that say that you've been handed and you've signed off on, but it just doesn't make any sense to you because you got to get out of the truck so often. And so you don't do it. You click the seatbelt behind you and you make your deliveries. And you don't think anything of it until one day, of course, you get in a wreck on the job. And the wreck is so bad that you get, thrown around the cab and your injuries are pretty bad. Yeah, the wreck is your fault, but you figure, okay, I'll get workers' compensation at least, right? So after you go ahead and file your claim and establish your claim with the insurance company, you get a letter from Workers' Comp Insurance that says they are denying the claim. Okay, why? Because they say that you willfully committed a safety violation, okay, by failing to wear your seatbelt at the time of the accident. Okay, let's take one other scenario before we begin to address this. You're a roofer. It's over 6 feet up on the roof, and you're putting on some new shingles, and there's some leaves on the roof, and you slip off, and you get busted up really bad. And you make a workers' compensation claim, only to find out that, again, you get a letter from the workers' compensation insurance company that says your claim is being denied because you failed to tie off while working at height. When you get this letter, you are absolutely furious because you know that no one that works for this company ever ties off. Why? Because the employer discourages it actually and says, look, unless we're working someplace where we know OSHA's probably going to show up, like a busy place in the city or something, let's not do that because it's a waste of time and we need to get the job done. We need to get on to the next job. I'm Joe Miller, workers' compensation attorney in both Virginia and North Carolina, and that's what we're going to talk about today, the defense in a workers' compensation claim of a safety violation, that the defense, the insurance company is saying that you committed what's called a willful safety violation or a safety law that is enforced by the company. A willful violation of a safety rule is a complete bar to any recovery. It's a complete defense. You won't get a penny if they're able to prove it. Now, for you law geeks out there, if you want to look this up, if you don't believe me, it's at Virginia Code 65.2-306. It's all laid out over there if you want to look at it. Now, we're going to limit our discussion today to Virginia workers' compensation. Why? Because in North Carolina is very different than this. They have a rule that says that if you're proved to have violated a safety rule, it's only going to reduce your recovery by 10%. Conversely, if you can prove the company violated a safety rule and it contributed or caused you to get hurt, your recovery will increase by 10%. But Virginia doesn't have anything like that. In Virginia, if they can prove you willfully violated a safety rule, you get zero. What are we talking about when we say a safety rule? What does that mean? So we're talking about a rule that's established by the employer for your safety. And typically, especially in the larger companies, you will find that it's distributed to every employee by way of a written set of rules. Usually it's some kind of handbook or something. You're usually given a copy of it. You're required to sign off on it. It says when you received it, etc. And that's usually at the beginning of your employment. Sometimes they'll update the rules or have supplemental rules that they make you sign off on every year. If it can be shown that you knew about the rule and it's been adopted by the employer and they told you about it, you intentionally ignored the rule anyway, then you're going to be barred from recovery, whether it's written or not. So let's go on to this other word, though, that the Virginia legislature saw fit to put in this law, which says that the violation of the rule has to be willful. Okay, what does that mean, willful? So it means that it's something simply that you knew about before your injury, okay, and that it was enforced by the employer, and despite the fact that you knew about it, you intentionally ignored or violated the rule, which caused or contributed to your injuries. And that's another part we'll get to in a moment, okay? So our first example we started this video with was that, you remember we said that the driver knew, okay, about this safety rule that you have to wear your seatbelt at all times, that it was enforced and talked to him about at safety meetings, okay, and that it was written down and he had signed off on the safety rules. So he intentionally ignored it by clicking together the seatbelt behind him whenever he made his deliveries, and when he got in a wreck, he was thrown around the cab. That's important too, we'll talk about in a minute. And his injuries were much worse than they would have been had he not worn a seatbelt. So this guy might be, and probably is, out of luck. And it doesn't have a case because he willfully violated a known safety rule. And not only that, but the fact that he violated the rule pretty much contributed severely to his injuries. Now let's talk about a second situation with the guy up on the roof, okay, who didn't tie off. Everyone who works at heights, as a roofer, and has done it for any length of time, knows that OSHA says that if you're working over 6 feet, you got to tie off, right? And you got to wear fall protection. That's the rule. Roofers are going to typically employ, as we know, roof anchors, which are going to anchor them near where they're working or at the top of the roof, and they're used to tie off, with ropes to the harnesses. So if they get in a situation where they slip, they don't fall off the roof. So in our particular scenario, though, if you recall, this employer never required anyone to tie off. In fact, they kind of discouraged it, right? Except when maybe OSHA was coming by to make sure people had their harnesses on. Turns out, in that scenario, that same morning, this guy had been working with other guys, and none of them were wearing their harnesses either. In fact, this just was never a thing. So in that scenario, first of all, we don't have a written rule. Okay, this particular employer, let's say, did not have a written rule in that scenario. We have a safety law and also a statute, the OSHA rule, that you got to tie off at heights. But the employer not only never enforced the rule, but kind of discouraged people from following the rules. It wasn't part of anything that was enforced in employment, so he's just doing what his employer tells him to do. So it was not willful. We all know in the real world, as they say, ignorance of the law is no excuse, and you can't come to a cop gets you for violating a law. You can't just say, well, everybody else is doing it. Well, in workers' comp, with regard to safety rules, it doesn't really work that way, okay? And you can actually use that as an excuse if it's true that, hey, this employer was not enforcing this rule. So what am I supposed to do? I mean, my employer tells me, hey, don't waste time putting on the harness when we're going up on a roof over here. We got to get this job done and get out of here. That would not be a willful violation, and I think that guy would be okay. In fact, we had that scenario, and he was okay. Unless workers' compensation insurance company in that scenario can show that the rule about tying off was enforced on this job, whether written or not, seems to me the employer is going to have a really serious problem showing that this guy violated a safety rule. What if you're a truck or delivery driver and you're in an accident and you were speeding at the time of the accident? I mean, that's against the law, right? The safety law. It's a law that's passed for your safety. Is that defense, if they come back with that defense, is that going to fly? It's going to depend on two things to start with, which is going to lead us to a third potential answer we'll get to in a second. So let's talk about the first two things. Let's say the employer had a written rule about never going over the speed limit ever, always driving within the speed limit. What if in this situation that this guy who's driving the truck at the time of the accident is going 5 miles over the speed limit? So it appears you violated the rule, right? But then we have a second piece of analysis, right, that we got to get to, and that is, was the violation willful? Okay, well, the guy knew about the law, but was he really conscious that maybe he spaced out while he was driving? He didn't really know that he was driving 5 miles an hour and over. He just got a little distracted or something. That's probably not willful enough to get them over the hump on that defense. Although if he says, it's just my policy that I always drive 5 miles an hour over the speed limit. I know about the rule, yeah, but I just always do that. Well, then you got a problem there. You're looking at me now and going, you telling me, Mr. Miller, that a guy that's driving 5 miles an hour over the speed limit, who's hurt and gets in a wreck, is going to be prevented from making a claim because he was going 5 miles an hour over the speed limit? No, not necessarily. Why? Because remember about the other thing we discussed, and that is, not only do you have to have a willful violation, but it has to contribute to the injuries. So you're going to tell me that somebody whose tire blew out, or who jackknifed, or got somebody just randomly ran into him, that all happened because, and this guy was injured because he was going 5 miles an hour over the speed limit? I don't see how they're going to prove that. So I think you would be okay on that because you don't have the causation element. And that's in the first line that you'll see in the statute. It's got to be caused by. Accident or injuries have to be caused by a willful violation. And in that case, a 5 mile an hour increase over the speed limit, probably not going to be caused. Now, what if that same trucker is going 25 miles an hour over the speed limit instead of 5 miles an hour on speed limits? Okay, so in Virginia, we know that 20 miles an hour and above over the speed limit is considered automatically reckless driving. So not only speeding, you can be convicted of reckless driving. So that certainly would be a different story. I think it'd be very hard for him to argue, the injured worker to argue that, that first of all, that wasn't willful. Also, there's a good chance that you'd be able to show, the defense will be able to show that that contributed to the accident, that he was going that fast over the speed limit. Now, what about that very first situation we mentioned with the seatbelt? Let's apply this causation rule. All right. What about if that guy who failed to wear the seatbelt? What if he forgot to wear the seatbelt, but it was just a rear-end collision and he wasn't tossed around the cab and he was hurt, or some large piece of debris crashed through the window and him in the driver's seat, or he was rear-ended and and suffered a severe whiplash and a concussion or something like that? How would it have made a difference if he had worn a seatbelt? Probably wouldn't have made much of a difference. Okay, I think it'd be, if he wasn't tossed around the cab, they may not be able to show that the failure to wear a seatbelt, contributed to his injuries or contributed to the accident. As long as the failure to wear the seatbelt really had nothing to do with the injuries that he suffered, you're probably going to be okay. So we hope this video has illuminated this idea about this defense of a willful violation of a safety rule. If you or a loved one have been hurt in an accident in Virginia or North Carolina, if you have any questions about whether your case may fit into this situation, or they've told you that you violated a safety rule or anything like that, or you just want to know about workers' comp, please don't hesitate to give us a call here at the number on the screen, or contact us via email, however you wish to contact us, or go online and take a look at our website. We'd be happy to help you. Again, this is Joe Miller, workers' compensation attorney. Joe Miller out.